Mr. President, I rise in opposition to the nomination of John Bush, nominated to serve a lifetime appointment on the Sixth Circuit Court of Appeals. The Federal Court of Appeals has significant impact on the lives of many Americans. Because the Supreme Court only reviews a limited number of cases each year, decisions by the circuit courts represent the final word on thousands of legal matters that involve a host of important issues. The Senate has to take very seriously its obligation to consider candidates for this important court. We have to make sure they have the qualifications, the temperament, and the judgment to serve for the rest of their lives. Based on Mr. Bush's record and his testimony before the Judiciary Committee, I believe he falls short of this standard. Over the course of his legal career, Mr. Bush has made dozens of provocative comments, casting serious doubt on his temperament, his judgment, his impartiality, and his ability to serve as a fair and impartial judge. Consider the following things which this nominee has said or done. In 2008, Mr. Bush compared abortion to slavery, writing, and I quote, in an anonymous blog I might add, quote, "The two greatest tragedies in our country, slavery and abortion, relied on similar reasoning and activist judges at the U.S. Supreme Court, first in the Dred Scott decision and later in Roe," end of quote. So Senator Feinstein and I decided to ask Mr. Bush to explain. He did not disavow the comparison that he made in this anonymous blog. Here's what he said instead. He claimed that he had referred to Roe versus Wade as a tragedy, quote, "in the sense that it divided our country," close quote. So I asked Mr. Bush to explain his logic, asking whether he would characterize Brown versus the Board of Education as a case that divided our country. He answered, and I quote, "I wasn't alive at the time of Brown, but I don't think it did," end of quote. That's an incredible statement made by a man who seeks to serve on a federal circuit court for the rest of his life. His logic and his historical analogy have fallen apart. There is no dispute that Brown versus Board of Education, which ended up in the official desegregation of public schools across America, was a landmark Supreme Court decision that deemed racial segregation unconstitutional, and as a result, led to controversy and division across the United States. I can't believe that a man from Kentucky, a border state, much the same as my state of Illinois, in fact, a neighboring state, could not measure the impact of Brown versus Board of Education and whether it divided our country. That to me is incredible. And the reason, of course, he didn't is because he didn't want to concede, quite obviously, that he was just opposed to a woman's right to choose. And this was a rationalization for that position. There are many other instances in which Mr. Bush expressed provocative and troubling views. He wrote that public financing of election campaigns is, quote, "constitutionally dubious." And he went on to say, runs afoul of constitutional guarantees by forcing taxpayers to subsidize candidates' political speech in contravention of those taxpayers' First Amendment rights. This is a view which is hard to understand because it contradicts decades of Supreme Court precedent. Mr. Bush, seeking this opportunity to serve for the rest of his life on a federal court, has now questioned a Supreme Court precedent which has been on the books for years. He gave a speech where, sadly, he made an anti-gay slur about the town of Louisville, Kentucky. He wrote blog posts supporting the nomination of a voter suppression advocate, Hans von Spakovsky, to the Federal Election Commission. In response to a written question which I sent to him, he refused to disavow President Trump's claim that 3 to 5 million people voted illegally in 2016. He said it was, quote, "the subject of political debate." That assertion by the president has been rejected and discredited by every objective person who's been challenged. but not Mr. Bush, who seeks this lifetime appointment to the court. Mr. Bush wrote blog posts that repeatedly placed the terms, quote, global warming and, quote, climate change, in quotes, insinuating they did not exist. He described then House Speaker Nancy Pelosi as, quote, Mama Pelosi, close quote, and wrote that someone should, quote, gag the House Speaker, close quote. He posted articles from right-wing websites speculating that former President Barack Obama was born in Kenya. He wrote in a blog post during the 2016 Republican National Convention, quote, time to roll with Trump. The list of comments goes on and on. On a range of policies and legal issues, Mr. Bush has already made crystal clear where he stands. At his hearing, Mr. Bush asked the Judiciary Committee to trust that he could completely set aside everything which I have read into the record this morning. He can walk away from his personal views if he's confirmed to serve on the circuit court. Unfortunately, he's given us little reason to trust that assurance. He has no judicial experience demonstrating that he could be impartial. He spent his entire career in private practice. At his hearing before the Judiciary Committee, Mr. Bush was asked by Senator Tillis, Republican senator, do you think that impartiality is an aspiration or an absolute expectation? Mr. Bush responded, and I quote, it is an aspiration. I will do my best to be impartial. In other words, Mr. Bush claims that he will try to be impartial, but the Senate shouldn't expect that he will be completely successful. Here's what Senator Tillis, my Republican colleague, then said in reply. I actually have a concern with someone who thinks impartiality is an aspiration. I think it's an expectation. Well, I agree with Senator Tillis. And I believe Mr. Bush's failure to commit to impartiality really disqualifies him from this lifetime position. Mr. Bush's views are far outside the judicial mainstream. He's provided no evidence that he could set aside his views if confirmed. I understand that Mr. Bush does check many of the boxes that we've seen for recent nominees from this administration. Most important and absolutely essential to his nomination is the fact that he is a longtime member of the Federalist Society. The Federalist Society describes itself, and I quote, a group of conservatives and libertarians dedicated to reforming the current legal order. The Federalist Society is funded by big money, right-wing interests like the Koch brothers, the Chamber of Commerce, the Ed Uline Family Foundation. This is the group that President Trump personally thanked for selecting his list of Supreme Court nominee finalists. So far this year, every Trump judicial nominee who's had a hearing before our Senate Judiciary Committee has been a Federalist Society member. Coincidence? I don't think so. I would urge my Republican colleagues not to let the Federalist Society serve as the selection committee, the secret handshake to become a federal judge for life in the United States of America. We want a federal bench that welcomes independent and impartial thinkers. Mr. Bush's Federalist Society membership shouldn't be his ticket to the federal bench. In conclusion, this vote, when it comes to his nomination, is really not a close call. It is clear that Mr. Bush has friends in high places, but he's demonstrated a temperament and a judgment which we should not put in a lifetime position on the federal courts of appeal. I urge my colleagues to oppose his nomination.